Schoolhouse Rock lied. Yes, that Schoolhouse Rock. The song isn't factually incorrect. It educates us about how a bill becomes a law, but the song is misleading. After a law goes into effect, its story is just beginning. That's because laws are enacted. They touch our everyday lives. They're complicated, and they can change. So a law doesn't just become a law, it becomes a reference for how society must comport itself, and it's a catalyst for administrative action. For newly established food processing standards, the USDA must inspect plants to ensure compliance. When student loan repayments paused during COVID, the Department of Education had to coordinate with all the loan servicers to get the word out. But this is a drug policy podcast, so you're probably wondering who the USDA equivalent might be for drug laws. Who do prosecutors, criminal defense attorneys, and federal judges turn to when the rules of the game change? The answer? A commission. Not a court, not an administration, a commission. Specifically, the United States Sentencing Commission. The U.S. Sentencing Commission was created in 1984 to reduce sentencing disparities and promote transparency and proportionality in sentencing. It's a bipartisan, independent agency located in the judicial branch of government. They're continuously researching sentencing issues and establishing and amending sentencing guidelines for the judicial branch, and they assist Congress and the executive branch with developing effective and efficient crime policy. Like I said, laws are complicated, and criminal sentencing laws have become so complicated that the United States Sentencing Commission developed an online calculator that converts drug amounts to offense levels, and they established a telephone helpline for legal practitioners. Up until recently, the U.S. Sentencing Commission was out of commission, literally. But now that they have the number of commissioners required for a quorum, they've hit the ground running. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we're talking about the United States Sentencing Commission. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. Drugs on the Docket is coming to you from Haggerty Hall on OSU's main campus in the Digital Union. Got a special guest here, and you know more about him than I do.
Thank you, Hannah. And so very excited to have the chair of the U.S. Sentencing Commission, Judge Carlton Reeves, joining us. He just gave a terrific Menard lecture for the law school community, and now we're taking advantage of his presence here on campus to tape a segment of Drugs on the Docket to really lean into the work of the commission and let Judge Reeves talk about his involvement, which was covered a little bit during the lecture, but I have some good follow-up questions. Judge Reeves, if you can give a little bit just a background of kind of who the commission is, how you all function, both in reviewing the guidelines and in setting priorities for the work of the commission.
Well, first of all, thank you all so much for having me. I really appreciate the hospitality that you all have shown me here at Ohio State. Make me feel like I'm still in Mississippi. So I appreciate that so much. With respect to the commission, it's a bipartisan commission that was set up in 1984 under the Sentencing Reform Act. And it requires that there's a group of 7 commissioners. The party in power has 4 commissioners, and the minority party would have 3 commissioners. We were all confirmed as a slate in August of 2022, a group of 7 of us. There are 3 vice chairs. I am the chair, and then that leaves 2 other commissioners. The vice chairs are Laura Mate, who work with the Sentencing Resource Commission or Committee, and there's Judge Phil Restrepo, who actually serves on the Third Circuit Court of Appeals, and then Vice Chair Claire Murray, who was a Principal Deputy Associate Attorney General. Then there's Candace Wong, who is an AUSA in D.C., and John Gleason, who is a former judge in the Eastern District of New York. And the other commissioner is Claria Boone. She's a sitting judge in the Eastern District and Western District of Kentucky. So we make up the collective of 7 commissioners. The commission has a staff. It's a staff of about 100 and some odd employees, most of whom are dealing with our research function. And then we have some policy people, a group of trainers who train judges, probation officers, practitioners on our sentencing guidelines. And that basically makes up the full commission. We have, legal counsel, group of lawyers who advise us on our policies, practice, procedures, and things of that nature. Our goal is to implement sentencing policy that reduces disparity in sentencing. If a person is convicted in Mississippi, and that case is tried before Judge Reeves, if that same individual were to be convicted of the same crime in Billings, Montana, he or she should get about the same type of sentence that he would have or that he got before Judge Reeves.
Ensuring similarly situated defendants get similar sentences is very much a part of the mandate that Congress gave you. But I sense you have a fair amount of discretion, you might say, as a commission in choosing what issues to prioritize, what should be the focus of the commission's work. And I'm curious first whether you spoke to some former chairs before you took the role about how they went about defining priorities for the commission's work. And then the federal sentencing system is so vast. There are so many issues. I know there are many people who submit comments encouraging you to work on this topic or that topic. Is it a collective enterprise? Is it critical for the chair to sort of drive the ship, or else you'll get distracted by all the different topics without having you give away any behind the scenes secrets? How does the sort of day-to-day work function? And how did you take on as chair to what seems like a very challenging job?
It is critical, and it is a collective effort. I did talk to many of the former chairs, Patty Sayers, who are the one who I probably knew most, and also the staff. Although the commission itself had been dormant because there was no quorum, by the time we were confirmed, there was only one commissioner, the acting chair, and that was Judge Charles Breyer. So many of the things that past commissions had started and could not get done because of the lack of a quorum, we agreed that we would pick up some of those things. We were advised by the staff that this is the work that they had been doing. You all might consider this. And we agreed to take up quite a bit of those loose things when we came aboard. And the way that we get our priorities from year to year, we have a planning session in May, and we sit around and we talk about those things that we think that we ought to sort of go into. And then we come out of our May meeting and we'll announce, we are thinking about these things, but tell us what you might be thinking about. And that the public is allowed to weigh in and offer comment. And then we decide in the fall what the priorities for the given year might be by, again, having relied on staff, having looked at things that we brought to the table back at our May planning session, and then seeing what the public comment is, because we gain a lot from what the public says it ought to be, because the stakeholders are also giving us their thoughts on what it is that might be broken, that might need to be fixed, and all that. And then from there, we do agree on what will be the priorities for this year. And that's what we've done again. And now we're getting ready we've received thousands of comments based on what our existing priorities are, and we're getting ready to have hearings on it later this week. And we will have testimony by the stakeholders and everyone else. And then from there, we will deliberate. We will see where we go, see how much we were convinced by whatever testimony. Finally, we'll have a vote in April about what it is that we wish to submit to Congress. Whatever we submit to Congress will be submitted by May 1st. And then Congress has until November 1 to accept what we've done or to reject what we've done. And in order to reject it, they have to go through which is something that I did learn coming aboard. It has to be just like, I'm just a bill. These young people don't know that.
Yeah, we do. Yeah, we do. We do.
Schoolhouse rock, They have to go through a real formal process of literally overturning what it is we might have done. And then they have until November to act. But while they are preparing to act by November, we will have started another cycle for the next year.
So that is a full-time job. It certainly sounds like a full-time job. And yet you have another full-time job, which is you're a federal district judge in the Southern District of Mississippi. And so I guess I'd love to hear you speak to both, the challenges of doing both of those full-time jobs, or whether you think it gives you kind of extra insight in serving as the chair of the Sentencing Commission, both when you go back and have individual cases that you need to sentence, and then sort of vice versa, that you are and have been a sentencing judge for more than a decade, how that helps inform the work that you're doing, trying to make the general sentencing rules at the commission.
Yes, we sit as judges full-time in our districts. And it's not daunting because, again, we have real capable people at the commission. I imagine the judges, like me, have great law clerks back in our chambers, and we're able to do it. It is a lot of work, but it's a bunch of committed people at the commission, and that makes it so much easier because you have people deeply involved in trying to make this system better. And as long as everybody working toward making it better, it makes it easier for us to work together to making it better.
I'll editorialize a little and kind of highlight that anybody who gets discouraged about, nothing gets done in Washington, or, political division keeps anything from moving forward effectively. You've done an amazing job in just a couple of years of the commission in advancing so many amendments to the guidelines, responding to past congressional legislation. And, it's a bipartisan commission. It seems like you all work together terrifically well to keep moving forward with priorities rather than fight for the sake of fighting, even though I know there are differences of opinions. If you watch your hearings, you can sort of tell that different commissioners may come at issues in different ways, partially because they have different backgrounds. But it's been heartening to see, especially after the commission for a number of years had lacked a quorum, to see how you've been able to move forward with that work. Because the name of our podcast is Drugs on the Docket, I'm going to lean into drugs a little bit here. The drug guidelines have been subject to criticism for, literally decades. And one big part of that, I think, is how the quantity of drugs end up becoming the kind of key consideration when the guidelines get calculated. And my understanding from the history was that, it's because Congress put in the statutes, in their mandatory minimums, all of these quantity-based triggers for different sentencing minimums. And that led the original commission to build the guidelines around the same drug table, the drug quantities being at the core. Is that something that could possibly be a priority in years to come, to kind of take a big, bold look at just the way in which drug cases get analyzed? Or is there some sense that, unless Congress changes those sort of baseline mandatory minimums, the commission somewhat hamstrung in their ability to kind of rework the guidelines, given that they were built on top of mandates that Congress put in place that they've changed a little bit, but not changed dramatically over all the years?
We do have certain directives from Congress, for example, deal with ghost guns or look at fentanyl, deal with that. But Doug, what I've done, made a commitment to do over the last year or so that I've been chair, I make sure that I was meeting with various judicial conferences, and we had national training for our judges, and we had national training for the probation officers. And we always ask and inquire from people. We're starting to hear from my colleagues who've been on the bench 25 and 30 years, and they're talking about people who they sentence to prison who are still in prison because they got ensnared in a scheme, a conspiracy or whatever, and the amount of drugs pushed them into areas of having to impose a sentence of 20 or 30 years. But in public spaces and through our portal, judges and others have said, what about this delinking, as they call it? Delinking the drug quantities from the drug sentences and not making sure that the quantity drives the sentence. It's not on our agenda this year, but I won't be surprised if we continue to hear it from our colleagues, particularly how we might address their concerns.
For sentence reductions, am I wrong to think that maybe among the reasons you're hearing from more of your colleagues about these 20, 30, 40-year sentences that they had to oppose long ago is they're now getting motions for sentence reductions that are now available after the First Step Act, and they're looking to help from the commission for guidance on how to deal with those sets of cases, given the reality that they now have authority after the First Step Act to request a sentence reduction and may or may not be able to convince the original sentencing judge that they should change it just because it was a bad idea way back when, right? They want more factors to help them understand when they should reduce a sentence or when they should leave those sentences in place.
I think you're right. They started seeing a rash of the compassionate release motions during the COVID era. You know, in the federal system, we pride ourselves on truth in sentencing. So basically, every month that you're going to get, you're basically going to serve that month. So when you give a sentence of 240 months, that's a 20-year sentence to a person who might have been 20 years old at the time, or to a person who might have been 40 years old at the time and is now over 65 and is a totally different person. But judges saw that their hands were strapped and they could not do anything post-sentencing. And 240 months is nothing for drug crimes. I mean, you can get 360 months in a heartbeat or even more than that.
Our center had a researcher do a report highlighting just how many life sentences were given just for drug offenses back in the 80s and 90s. And those have decreased over time, but the extreme length of some sentences, drug-based, were just extraordinary for quite a period of time.
Could I add this one other point? The other thing is the cost of incarceration. Judges now, in every pre-sentence report we receive, we know that it costs about $50,000 a year, $49,000 and some change a year to incarcerate an individual, as opposed to about $5,000, a little bit less than supervised release.
And that actually leads to, I know, a topic that the commission has started to do some work on, and you've put some materials on your website that are terrific that help understand what's already going on in the federal system, but looking at alternatives to incarceration and, you know, wondering whether there's a sense, you know, maybe among the commissioners, maybe among the comments that you're getting, that these drug cases may be uniquely appropriate, at least for some of the lower level offenders and folks who have been caught up in drug rings where they don't have a long criminal history, that developing more alternatives to incarcerations that federal judges can use might be another way to, whether it's cost savings, whether it's just helping to ensure persons don't recidivate, because you were mentioning in your lecture this afternoon the degree to which going to prison may be itself a driver of recidivism rather than getting the kind of programming and alternatives that might be appropriate. And so I know, you know, your commission's looking at some of these issues. Is there things we should be looking out for, or, you know, is that likely to be another component of coming agendas to explore alternatives?
Yeah, absolutely. The alternatives is a big thing in the state systems and even in the federal system. Judge Reggie Walton, for example, has been doing a drug court program for a number of years now. And we attended that program just to see what it was like. And it is amazing.
I know that the Sentencing Commission is looking specifically at all these drug courts, but they're named something different across all state jurisdictions. But you have maybe more appropriately called them resource courts, and the Sentencing Commission has become somewhat of a clearinghouse for best practices. Is there any more that we can expect to see from the Sentencing Commission with regard to resource courts?
Yeah, I think so. After this round of hearings, hopefully we will get a better sense of what all the different districts are doing. Some of them have reentry programs. Some of them have drug diversion programs, veteran court programs, mental health court programs. It's a variety of programs, and many times people go into prison having been a broken individual. And by and large, whatever sentence anybody gets in the federal system, for the most part, you get very few life sentences. For the most part, you will serve that sentence. The thing is making sure that when you come back home, you're able to live outside of that prison system in a way where you don't recidivate, in a way where you won't be constrained by the pressures of life that you're coming back to, because society is going to be society, and you're going to have to be able to withstand those pressures and all that. And hopefully these alternative courts, you know, the diversion court on the front end may be great for the young person who has never done anything, gotten caught up in this one thing. Well, let's see if we can figure out how we can work with you to not even go into prison and see if that works. So we're just looking at all the types of programs that vary from across the country. And we just trying to make sure that people's programs, circuits, and the district's programs that are working wonderfully are adopted.
So it's accurate that the Sentencing Commission is only looking at federal courts, circuits, and district courts.
We're getting information on all of them.
The scope of which courts you are looking at is just federal courts. You're not necessarily, because it seems that there are state courts that are looking to the federal courts for guidance on how to.
The state courts in this area, the state courts have been far more creative than the federal courts.
But generally, not a lot of consistency in terms of how the resources are.
Right. No,
whether it's diversion or reentry.
Okay. Everybody suffers from the lack of resources. Mm-hmm. And of course, the real push now, you got to understand that there are some people push for there needs to be prisons. The huge debate right now is not a debate. I think every statistical measure shows that crime is actually down, everything that we've seen. But you hear about the one or two really bad cases and you know that crime must be crazy everywhere. But I think every statistic shows, everybody who's studying it shows that crime is actually down. But you'll never hear that for the chatter of all the crimes that are being covered.
Yeah, and oftentimes D.C. is a good example these days where there's a spike in one particular region and that becomes the focal point. What's going wrong in D.C.? Or there'll be other regions where there'll be one type of crime. Carjacking's got a lot of attention as well. And that becomes the focal point, the classic, if it bleeds, it leads. But it makes it very challenging to dispel the assumption that there's a problem that has to be addressed through just the hammer of imprisonment rather than through these other more nuanced means. The challenge that you face in doing your work as a commission, though I know you have a wonderful staff and data to try to stay focused on the true story rather than just what the headlines provide. Back on the drug front, I'm wondering, your commission did a terrific report a couple years ago on just marijuana offenses and the way in which people with even low-level marijuana offenses might have that affect their criminal history and the way in which that might impact future sentencing for a federal offense. But it looks like there's at least the administrative process underway to possibly reschedule marijuana to go from Schedule 1 to Schedule 3. I'm curious whether that kind of change would be among the things that could create a priority going forward, or it'll be up to Congress to let you know.
It could. And, the research guides us, and we could issue directives or policy statements, amendments, guidelines. I mean, we can do a lot. And at least elevating the conversation, I believe, helps the general public and helps us.
You were sort of describing a little bit kind of the range of tools that the commission has. And I do think, and this was really the only tool when it was lacking a quorum, was producing a number of research reports, incredible work that the commission did on recidivism and on a range of other matters. Is most of the research connected to the priorities that you all have identified in the amendment cycle? Is it research that maybe can individual members of Congress reach out to the commission and say, we'd like to see a study on fentanyl or this or that, whatever it might be? I'm curious about how much the commission, and especially the research staff, is mostly focused on servicing the guidelines, or is it about sort of servicing our broader understanding of how federal sentencing functions and the wider range of issues that arise day to day for judges?
A lot of the research is based on older research trying to update what was done 10 or 15 years ago. So that's a good pocket of already having something to do. And the research staff itself brings to us propositions and things that we ought to be looking at, and we sanction that the research gets done. And the commissioners, one of the things that we are always mindful of, not our single most important thing, but trying to eradicate the disparity. So all of these things that might go into identifying disparity or resulting in disparity, or disparity not having been reduced, we need to find out, why is that the case? Is it the charging decision of the prosecutors? Is it regions of the country? Is it the judges? We look at all of those things to get information. And again, the research staff too comes up with a bunch of stuff because they are researchers.
So I have one last substantive question, and this one's going to be way too wonky, but hopefully you get a kick out of it being way too wonky. The commission for decades, and this is built on top of widespread concerns or criticisms of the guidelines for simply being too complicated. The book of guidelines is massive, and it's just grown over the years. And I know the commission has long identified trying to simplify the guidelines as sort of a background priority and commitment. And yet it hasn't gotten much simpler. We can blame the courts a little bit for that. Am I wrong to think that one of the reasons why the commission hasn't been able to advance a more robust simplification agenda is because it's almost impossible now to simplify things? Or is it something a little bit more foundational, which is, people like the idea of simplification in general, but then when they see how you're suggesting simplification, they don't like that this part of the guidelines is getting eliminated or that part's being preserved. I'm just sort of curious to get your sort of take on that broad project of simplification and and some of the challenges it poses.
Stay tuned because we have hearings this week, and we do have in the eyes of some, it may be a modest simplification proposal. In the eyes of others, it's pretty bold because the simplification proposal out there simply tries to acknowledge we're at an advisory system, guideline system now. The manual was created pre-Booker, and we followed that sort of manual where you have to go through these various steps to get to where you want to go. But one of the versions of the simplification proposal takes away one of those steps because you have the 18 USC 3553A factors. Ultimately, what they impose is a fair and just sentence, a sentence which is sufficient under the statutes, but not greater than necessary. So you don't have to even think about departures and all of that stuff. If you go through the 3553A factors, you get to where you need to go. Because I was told, when I got here, Judge, you know how thin the guideline manual was when I started? I'm talking to my old colleagues and others. Right. They talk about it being a little bitty guideline. Now it's 1.5 inches or 2 thick now. I've seen some of the comments. I'm very interested in the testimony we'll receive. That type of input coming from people we think is going to be very, very helpful to us reaching that ultimate goal because simplification has been on the agenda for many years.
Do you get a sense that the U.S. Sentencing Commission is sensitive to the changes that take place at the executive level? So when you have a new president coming in, are there directives for you to don't look too intently at things, or from Congress to don't dive into things as much? Do you ever have your hands bound to be like, well, we can't really do anything right now because of who is in power?
We're not necessarily responsive to one individual or the change in leadership because DOJ changes, right? Mm-hmm. And DOJ changes with administrations and with priorities on their charging decisions, on the types of cases they're going to push, on whether or not they'll continue to charge marijuana, small amounts of marijuana cases or the types of immigration cases. But we have to be cognizant of what the whole criminal justice system looks like. And we cannot necessarily be solely responsible to the dictates of the executive branch and try to make sure we work through what Congress has directed us to do. We get letters all the time from certain senators or from certain representatives about this is what you ought to do. And we take those comments like we take any other comment from the public, from judges and others. But as a collective commission, we don't feel that we have to necessarily do anything just because it is the voice of that particular individual. Now, if it's the collective voice of Congress, yes, we have to act.
I think to some degree, the commission's historic success at being insulated from politics, it was both created that way. It has to be bipartisan. It's structured with these staggered terms so that no new administration can, flood the agency with their nominees only and the like. And then the commission's work kind of goes into effect unless a full Congress rejects it. That also helps to insulate it. It's not like they have to convince Congress to pass something. And it's a wonderful way that it's insulated from politics, I think, helps ensure its work is sound and focused on exactly the right things that their governing statute calls for. The irony of these polarized times is the more insulated an entity is from politics, the more they're at risk of getting ignored and forgotten because the partisans are just, where's that branch I can control? Or where's that agency that I can put my imprint on? The commission is doing its work, often doing a great job of keeping that noise out, but they still need to function by having commissioners.
There was one commissioner at one point, one active commissioner.
That was Judge Charles Breyer. Yeah. He was the commissioner. He was the commissioner. He was the acting chair. And he laughs at me all the time. He'll call me up. Carlton, how's that day job going? Or how's that day job going? Everybody's term had expired, except his. He was over in a holdover year, and he was a single commissioner. So he could only basically sign off on budgetary matters, do the stuff that had to get done for the agency.
He kept the lights on.
Kept the lights on. There you go. But that was all. But the staff itself was still generating reports, which were valuable to the community, but no policy was being implemented.
But now we've got 7. Well, I'll wrap up then with just, are there things about the commission's work that maybe you didn't even fully know until you've been serving this role, or just sort of more generally things you now know that you'd like to make sure lawyers and non-lawyers understand about the commission's work? I mean, I just respect how much you've already done, but it's great to reinforce just the way in which you do your work.
All of our stuff is on www.ussc.gov. So we have our hearings there. You could pull up all the comments. You think about, as lawyers, particularly civil lawyers and all, the Federal Register and all that stuff that comes out on any agency proposal, we have to do the same thing. And these comments are all posted. And it is an amazing group of brilliant people who are following the work that we do and have opinions about the way that we're doing our work. So for you practitioners out there who are dabbling in or either fully immersed in federal criminal practice, you run into a brick wall on trying to figure out something. Don't stay at that brick wall. Call the commission. That's what our training team is there for. They will walk you through whatever that issue that you have. It's a 24-hour hotline now. A judge is likely to get a call back the same day or within 24 hours. Practitioner may get a call back a little bit longer than 24 hours if you call after hours. But if you call during hours, we're there. And so people take up these calls and they walk persons through the scenario that they're facing and all that stuff. It's a lot of resources out there. And you can get national information. You can get circuit information. You just can't get information on an individual judge. But that circuit information, that national information can help you argue your particular case as to why the judge ought to be doing something in this range. You don't want to be seen as sort of way out there. This person is much like the person in that other case. So it's the resources that we have that we make available to everyone. The Sentencing Commission is part of the public. We're public servants. We have an obligation to serve the public.
It really is a testament. I actually wish that every state would follow the lead, because the data at the state level is never as clear as you all try to make it at the federal level. So I really think that that's an important message to reinforce for everybody, that it's a great resource. And for non-lawyers or even lawyers that don't do sentencing work, it's really interesting too. It's an exciting year. I'm looking forward to seeing what you guys get done, especially because you have to do the work and I don't. So I just get to follow it. Thank you so much, Judge. It's been a pleasure having you on Drugs on the Docket. And having you here the whole day at Moritz.
It's my pleasure to be here.
So much.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.